Welcome, everybody. Let me make sure I can get my slides up on the screen here. Okay. It does make it a little bit more difficult for me to do some of this when I have to get people into the room. So I apologize for any times we might have a little snafu. So this is Power Broker Hour, June 2026, how to draft like a lawyer. So we are all allowed to do simple transactions. That's what Coltum versus Heritage House gave us the opportunity to practice law back in 1985. So in a few instances on a purchase agreement may be complicated and one or both parties may realize the need for a lawyer to prepare the contract rather than use a standardized form. In fact, if a broker or salesperson believes there may be complicated legal issues involved, he or she should persuade the parties to seek legal advice. More often, however, these transactions are simple enough so that standardized forms will suffice. Let me go back for a second. So we are allowed to practice simple transactions. Drafting of forms, per se agreements, is incidental to the main business of real estate brokers and salespersons. These individuals are specifically trained to provide buyers and sellers with competent and efficient assistance in purchasing or selling a home, because the selection and filling in of standardized forms by brokers, salespersons is an incidental service. That is what was voted in the Supreme Court back in 1985 so that we can physically do a few things. One, we can pick the forms, we can fill in the blanks for simple transactions where we're not simply filling out forms to get paid. Your warm-up question. We represent the seller. We have an agreement with a Form 22A and a 22AD, financing and additional down payment. That's what A stands for and AD stands for. The appraised value plus the amount on the 22AD is still less than the purchase price. On Form 22A, paragraph 2, box A is selected, and in paragraph A3, will is checked. Now, this is going to be hard since you don't have the forms in front of you. On Form 22AD, box 1 is checked. Today, we received a copy of the appraisal with the Form 22AAN. So that's a notice of low appraisal. I told my agent this is the incorrect form and that the buyer's agent should be using a Form 22ADN. Am I correct? Now, you need to know the difference between a 22AA and a 22A. Who in the chat box can answer that question for me? What is 22A and what is 22AA? Or you can unmute and speak. Unfortunately, I don't have the chat in front of me because of being on a... Let's stop sharing for a second. Nobody answered anything in the chat. What is 22A? Somebody throw it in the chat for me. Form 22A. I already told you what it was. I just didn't tell you what 22AA was. So who in chat can type the word for the Form 22A? Can you all hear me? Making sure I'm speaking by myself. Hi, Sam.
Hi, I can hear you.
Thank you. Okay, I've got it. Perfect. Financing. 22A is financing. Now in the chat, what is 22AA? They're both financial forms, but one has a different purpose.
Hey, Janine, this is Dan.
Hi,
So,
Dan.
hey, sorry to interrupt. I got here a couple of minutes late. Are we practicing for like the managing broker exam, or what is on the schedule
No,
for
this
today?
is the buyer broker hour for my firms.
Okay.
Appraisal addendum. Thank you. So you are either going to use a 22A or a 22AA. If your client is getting financing, they'll use a 22A. They want to be protected by the financing contingency and they want to be used by the appraisal contingency. 22AA says, I only want to be protected by the appraisal contingency. Okay, so that is the difference between the two forms. They are so confident they can get financing, but they want to make sure that the house appraises. And right now, houses aren't necessarily appraising. So let me get back into now we've got okay, let me stop sharing for just a second. I think I'm too, yep, hold on here. There we go. It's hard when I have to do this on Zoom and I can't always do it just in person. Otherwise, we would learn nothing because this is how we do things today. Okay, so 22A is the form that was used. 22AD is additional down payment if the property does not appraise. The buyer's agent sent over 22AAN. And I told my agent this is incorrect form because the buyer's agent should be using form 22ADN. Am I correct? Remember, we have a 22A, not a 22AA. So do we need a 22AAN or a 22ADN? So you got to remember which forms you're using. The second appraisal is for a different lender than the lender who wrote the pre-approval letter. Buyer did not notify us of a change in lender. Must buyer purchase at the agreed purchase price based on the form 22AD financing additional down payment? Has buyer waived financing contingency by switching lenders? Anybody want to come off mute, say, did the buyer waive their financing contingency? Okay, well, I'll tell you that the correct form that should have been used is 22ADN. Remember to follow the path of your notices forms based on the forms that you have chosen. So, discussion pointers for our warm-up question. Beginning with an analysis of form 22A and 22AD, paragraph 22A, excuse me, form 22A, paragraph 2 box, A is selected in paragraph A3. Will is checked. So significance, buyer's financing contingency will not waive by its own terms. Waiver will only occur if the buyer chooses to waive following receipt of buyer's notice to perform. So 22A, financing, paragraph 2, section A says that the seller must ask the buyer to waive their financing at the appropriate time. If you look at form 22A, box 2A, you will see that the default is 21 days. So making sure that you have, as a listing broker, you have told your seller what they are allowed to do. So come the 21st day, seller may ask the buyer to waive their financing. If the buyer waives the financing, then low appraisal protection is also waived. And they have the box checked that it will, significance of the buyer's financing, that it will not waive on its own term. Waiver will only occur if the buyer chooses to waive following receipt of seller's notice to perform. They also use the additional down payment form 22AD. If the buyer waives low appraisal protection, buyer must purchase at the agreed price. If the buyer's low appraisal protection is not waived, and if the buyer chooses to deliver notice of low appraisal, seller may either lower price to appraised value plus the amount on 22AD, or seller may terminate the purchase and sale agreement. Form 22ADN is the only notice that identifies the proper responses. So 22AAN is wrong if you have a 22A. If you have a 22AA, then 22AAN would be the appropriate one. Based on the facts, the buyer did not waive low appraisal protection, so buyer may deliver notice of low appraisal, causing seller to respond by lowering the price or terminate the contract. Because remember, the price came down, but it didn't come all the way down. Let me rephrase that. Let me go back one more. The appraised value plus the amount is still less than the purchase price. So even the AD, meaning the additional down payment, is still lower than what it appraised at. So it's $500,000 house. It appraised at $580,000, and the 22 AD said they'd bring in $5,000. So there'd be only a $5,000 gap that the buyer would have to bring in. So it's still not $20,000 below. So buyer only has to bring in $5,000. If the seller agrees, we move forward. If seller does not agree, the seller can terminate and the deal would die. So understanding low appraisals and notices is a very important piece of what we're talking about today. If you do have questions, you might have to unmute because I can't see your faces or raised hands, and I can't see a chat box. So please, if you have questions, just unmute and interrupt me. Discussion pointers for warm up of 2 of 2. So here is your waiver of financing. If the buyer fails to make application for financing for the property within the agreed time, changes the type of loan at any time without seller's prior consent. So we're going back to, has the buyer waived their financing by switching lenders? So this is what constitutes waiver of the contingency. Changes the lender without seller's prior written consent after the agreed upon time to apply for financing expires, or changes the lender from X. So this was a piece that was added not on tomorrow's form changes, but the form changes before. If you as a listing broker fill this in, the buyer cannot change their lender no matter what until seller has signed written consent. You'll notice if you look at page 1 of financing, if this is left blank, then it defaults to the paragraph above that says buyer has 5 days. So if this is filled in, buyer has lost their opportunity for their 5 days to look and shop. Okay, so know that that is something that is a change within the last forms. I think it was done in February of this year. So if you are looking at a 22A, paragraph 1A, buyer has 5 days to shop for a lender. Those 5 days go away if you as a listing broker fill in this blank and say XYZ lender. And that can mean the mortgage broker, the bank that they work for, whatever the situation is. So Form 22A, paragraph 1B, this revision here, this is 1B. Buyer's waiver of the financing contingency depends on whether the blank was completed, identifying the lender's pre-approval lender, meaning they had a pre-approval attached to the offer email, and you have filled this in now, and making it a waiver of financing contingency if the buyer changes lender without seller's consent. So I put in here ABC lending, and I want to change it. I now need seller's written consent. Second warm-up question. Our listing has been under contract for 2 months. Buyer's lender said everything was on schedule until a couple of days before closing, but then needed 2 more weeks. We extended with buyer making earnest money non-refundable. Now again, we're 2 days from closing and they want another extension. Lender is silent. Buyer's agent delivered a Form 34, which says financing has failed. This transaction is now to be contingent upon closing of a property identified on Form 22Q. Closing of this transaction shall be on 9/10 as stated on attached 22Y. They added Form 22Q. 22Q, by the way, is buyer's pending sale of their property. Tying it to our contract, they provided the pending sale contract closing 9/25, but also adding a 22Y for the contingent sale, changing the closing date to 9/10. Is it possible to add a 22Q to a current contract? Does this waive buyer's current financing contingency? Any other repercussions as buyers already released earnest money but tied up seller's property for 2 months? There should be a lot on your mind, so I want you to read this, since sometimes if I read it out loud, you're not internalizing it. So please read this and see what questions you have or what comes to your mind. So by changing the contract, what could happen to non-refundable earnest money?
Well, they're not
So
going to get
we've
it.
got, what was that?
They're not going to get it back. I mean, the earnest money goes to the seller.
Yes, but now we're changing the terms of the contract by adding in a 22Q, because remember, that's a new contingency. We had a non-financed offer, and where earnest money would also become non-refundable if the buyer breaches anyways. So number one, adding a new contingency could make the earnest money refundable because you're adding in a contingency you didn't have. The language was written poorly, number one. Brokers have drafted two conflicting provisions. You've got a closing date of 9/10 and a closing date of 9/25. The other thing that if you're ever going to make earnest money attached to an extension, you want to make it not a deposit, you want to make it an extension fee. The fee will help with making it non-refundable because most judges will find it based on contractual law, you have a contingency, therefore earnest money is refundable if buyer has not breached. All parties have agreed to add in this new contingency, which has opened up that earnest money again to become refundable. So, discussion points. Non-refundable earnest money. Transaction will now be contingent upon 22Q, meaning buyer's house was on the market, it's got an offer on it, but has not closed. So how is it that forfeiture of earnest money is seller's only remedy? It's not anymore because now they've opened up to give me another contingency. Does this waive buyer's financing contingency? They didn't have one, so it doesn't waive it. How does buyer have a financing contingency if earnest money is non-refundable? Form 22Q can be added to any transaction at any time, so that's fine. If the seller is giving the buyer a contingency as earnest money at stake, it depends. Other seller remedies, potentially. Is buyer's Form 22Q buyer is going to expedite the closing date? Consider using an extension fee rather than a non-refundable earnest money. The fee is paid in exchange for an extension. Refundability is not applicable and earnest money remains intact. So I feel that if you ever need an extension or you're in a multiple offer situation, I think there needs to be two different types of monies. I think there needs to be number one, an earnest money that is protected by the contract and any contingencies. And if the buyer really wants the seller to take their offer based on my earnest money is now yours, have it, give them a take my offer fee. That way, earnest money is still intact. You guys haven't made up interesting comments and discussions for classes by having interesting contracts that have non-refundable earnest money forms in them. Any other questions on that before I move on to drafting practice? So here's where you need to elevate your learning experiences on how you are going to draft contracts, how you are going to make sure that your clients' monies are protected, and making sure that you haven't created a viable or wrongful out for the other party by changing something in the contract. So that's what these classes are about. These classes are way better in person, and I know not everybody can always make them, so you'll have to bear with me as we go through some of these slides and talk about some of these talking points. There are two septic systems on the seller's property, one for the home and one for an RV. Buyer wants both to be covered by the Form 22S, which 22S is the inspection contingency. And remember that the septic inspection contingencies have different forms for different counties. So this would be like Snohomish County, but not King County, not Thurston. So you have to make sure that you're using the appropriate septic contingency. And does not want to be obligated to purchase unless both systems are in good shape. If I include Form 22S in the purchase and sale agreement, is the buyer's concern satisfied? If not, what should I do? So answering the question, is including Form 22S sufficient for both septic systems? I'm going to say no. It's not. It's not going to at least accomplish the goal of both systems. It will accomplish it for the property because the form, if you look at it, refers to a single system, not two systems. Okay. If you believe something more is required, pick the form you would use and draft language necessary to protect buyer's interest. What I would recommend in this situation is that you would take a Form 34 and you would draft language that is sufficient from your septic addendum and draft it exactly onto your Form 34, referencing the septic system for the RV. Now, when you do that, you have to remember that the 22S has contingencies in it, and you would need to make sure that there's language that ties them both together with the same inspection, and that the time period in the 22S would also work for your RV septic system inspection as well. So that is when you call me before you start drafting all the way so that I can help you through it. Counteroffers have become huge lately. And when I mean huge, I'm talking about the Form 36. More people are using them. I've talked to 3 people today that had to have them drafted. So this next section is rather long in the tooth in regards to Form 36. What is the best way to write a counteroffer? One, you can take your original offer and interlineate for simple pieces. Price change, closing date, some maybe closing costs in the financial 22A addendum, and making sure that it keeps it legible and it's understandable. Sometimes you're going to get it where it's so far gone that you will not be able to see half of what you've crossed out. Choose the right time. More often than not, interlineating is not the best choice, especially if you need to make a bunch of changes. And the expiration is determined by the boilerplate language of Form 21. And why and what does the boilerplate language say? It says it's a 2-day window. So once you counter, next person gets 2 days. If you counter again, you get 2 days, and so forth and so forth. Okay. That's if you simply interlineate on your purchase and sale agreement, i.e. a Form 21 or condominium, vacant land, and such. If you were to use the counteroffer addendum Form 36, what do you do with the counteroffers that are countered? Once you have mutual acceptance, are the counter offer parts of the purchase and sale agreement? The answer is yes. So understanding Form 36 and how it works, and we're going to go through that today. Should the counteroffers be given to escrow? Your answer is no. So this is if you take a 36 and you use it for your counteroffer. So Scott's the only one that's come off speaker, so I'm going to utilize his name today. So I have given Scott an offer. Client wants to counter my client's offer. He is going to use Form 36 to do so. He's going to send it to me with the changes. When I receive it and my buyer does not like what's on there, I am not going to strike through and counter offer on the counter offer Form 36. So you never counter offer on a Form 36. You get a whole new one out and you write what you want on there and make sure that whatever was written on the first one is very clear that it's not going to be part of the second one. So if I write on a Form 36, buyer brokerage compensation to be 3%, and I write that on there, but the seller counters the buyer and says, no, it's 2.5% and gives me a new 36. That doesn't necessarily change the fact that I've already asked for it. So I need to make sure that if I want it back in there, I've put it back on there, or Scott needs to make sure that when he's countering me, that he's very clear that request for buyer brokerage compensation at 3% is omitted. Buyer brokerage compensation is 2.5%. So being very clear, it's very hard to do that if you have to go back and forth a bunch of times. And remember, I have to ask for compensation from the seller based on what my buyer broker service agreement says with my buyer. When your buyer agreement says you charge your buyer 3%, you have to ask the seller to pay that 3% unless you're in a multiple offer situation and buyer says, I will pay the difference. And we have a form for that, okay? Then you would put exactly what the seller is offering or less, but then the credit either goes to your buyer or it can go back to the seller. It depends. And then I've signed a form with my buyer, again stating that you understand you are paying me X number percentage, because that goes to escrow, that goes to the lender. So it's very clear for the settlement statement, and the lender understands costs that are incurred by the buyer. Okay. That's just a side note. Should the counter offers be given to escrow? No. If this one is dead, you put it in your transaction folder, which means command. You put it somewhere in command and additional addendas, and we can see that it's dead because it's not signed around. And the new one is the only one that's attached to the purchase and sale agreement. Okay. So should they be retained in your firm's transaction folder? Absolutely. If I'm being told that if a seller makes a counteroffer on a buyer's expired offer, so no Form 36 is used, just terms changed in initials, that cannot be accepted by the buyer unless the seller also changes and initials the original offer expiration date. I believe a counteroffer is essentially a new offer, and the original offer expiration date is irrelevant. Am I right? I am being told that if the seller makes a counteroffer, let's start there. So I gave Scott an offer and it expires on June 9th at 9 p.m. Prior to June 9th at 9 p.m., or even after, Scott seller counters my buyer. So that offer expiration date at the top is now gone. It does not exist. That offer expiration date is what the buyer says, seller, you have until 9 p.m. tonight to accept my offer. If you do not, I'm not obligated to buy it. So a seller can either not respond, but if seller counters, that means seller is now asking my buyer to stay in the game, and buyer, will you accept my counter offer? Is what that means. So that means now that I have a chance as the buyer to, I've got 2 days now, because remember the boilerplate of the contract controls. I now have 2 days to either accept your offer, or the seller can withdraw it, or it simply goes away if I do nothing, or I can counter again, and now it becomes another counter offer to the seller. And so that counter offer just keeps going every 2 days, unless you use Form 36, where there's a hard date at the bottom, and that does not keep going. Okay. So if I do not change the buyer's offer expiration date on Form 21, would that establish the date of expiration for a seller's counteroffer to buyer? No. Doesn't matter. That's off the table because I'm getting a new offer as a buyer. The seller's now saying, I'm giving you an offer, buyer. So that date is relevant. That is true. How is this situation different from one where a seller wants to accept buyer's offer after buyer's offer has expired? So, different scenario. Well, same scenario, different outcome. I give you an offer. Scott takes this to a seller. Seller, you have until 9 p.m. on the 9th to accept my offer. It is now 9:31 p.m. and seller wants to accept my offer without countering. What you would simply do, listing agent, strike the offer expiration date, change it to 9:10 or 9:09 at 10 p.m. Your client initials it, sends it back to me. My client initials it. We go with the offer and how it stands. So once there's a counter, we have new expiration dates. But if seller wants to accept my offer and it's too late, they can simply change the top right-hand corner. That's where people get confused a lot. Oops. Form 36 counteroffer addenda. Used for the buyer or the seller for a counteroffer. Properly complete the preamble. You'll see that in the next slide what the preamble looks like, or at least soon. The preamble is what's at the top, and that'll be in the next couple of slides. Identify the counteroffer by some system not obvious to the third parties, meaning an address and such. Use a new Form 36 for each counteroffer. Never interlineate a Form 36. Creating a roadmap is unnecessary and likely confusing, but okay if you insist. That means if I want to take Form 36 and make the changes, I want to show you a roadmap by taking the rest of the purchase sale agreement and addendum and cross off what I'm referring to on Form 36. You don't have to do that. Form 36 controls the whole purchase and sale agreement unless it's changed by a Form 36. But you can make a roadmap if that helps you visualize a little bit better. If the seller is reluctant to sign Form 21 in fear that Form 36 is lost or unnoticed. So once Form 36 is signed, again, it controls everything attached to it, the purchase sale agreement, the addendums. None of those have to be signed if you're doing everything on a 36. Will the buyer have signed the purchase sale agreement and addendum? Yes, because that's the offer. But if the seller's counter offering with a Form 36, 36 is the only thing the seller has to sign. They do not have to sign the rest of it. Do I recommend they do so we can show that they understand that the rest of this is attached? Yes, but legally they don't have to. You do not have to write Form 36 on the addenda line, but you should and can because the addenda line is the index of all of your forms that you're using in the purchase and sale agreement. There are three things I never want you to write on the addenda line. Legal description, because that is already addressed up above in the purchase sale agreement as attached as Exhibit A. Form 17. Form 17 should never be made part of the purchase sale agreement. The legal description is part of the purchase sale agreement, but it's already stated it's attached at the top. Form 17 should never be attached, should never be written on the addenda line. Remember, when you send a signed Form 17 with your offer, if that's what you so choose to do, send it as a separate attachment in the same email. Do not attach it to the purchase sale agreement. And the third thing is FIRPTA. Both the 17 and FIRPTA 22E are simply disclosures from seller to buyer. Well, and seller to escrow if they have to collect money for the IRS. Again, neither of those are drop down in your actual addenda lines. Neither is the legal description. Both of those are disclosures. They are not part of the purchase sale agreement. There is no reason you as a buyer broker should ever grab Form 17 from supplements and attach it to the purchase and sale agreement. Your buyer hasn't signed it. They don't need to sign it unless the party is a foreign person for taxation purposes. But again, that can be signed and sent to escrow. It is not part of any of the purchase and sale agreement, nor should ever be sent back to the seller. FIRPTA doesn't even have to be given to the buyer. Our job as buyer brokers is that we have to confirm it's been received by escrow, and escrow can confirm if they're going to have a withholding for the IRS or not. Okay. Write subject attached counteroffer above seller's signature. Doesn't need to sign that. Physically locate Form 36 on top of all forms. Don't need to do that either. Draft like a lawyer when completing the big blank. That's what we can get ourselves into trouble, as drafting like an attorney. Oh, the chat showed up. Hold on. When we receive offers with the Form 17 or FIRPTA, etc. attached, do we ask the agent to resend or just accept it as is? Great question. Just accept it as is. Remove it from anything. So if you're going to counter one, you don't need to keep sending that same PDF back and forth. Create your PDF, remove Form 17, remove FIRPTA. It always kills me that buyer brokers send FIRPTA to the listing agents. There is no reason. I will never send it to the listing agent. I will never send it to the listing agent. I will make sure escrow has a copy if I'm the buyer broker. I'll also make sure that escrow has a copy if I'm the seller broker. And I don't care if we both do it as long as that gets done. Form 17, I actually don't have my client sign it, and I never send it back to the seller. I wait for the seller to send it to me to start my 3-day window. Remember, you don't have to sign Form 17, number one, ever. But you as a buyer broker need to make sure you 100% got a copy to your buyer, whether you had your client sign it or not. You can prove that you sent it to them. But I make sure that I'll always give a copy to my buyer, but I will never let the seller know I've done that, and I'll make the seller send it to me. There's a lot of loosey-goosey listing agents out there that have no idea what they should or should not do when it comes to Form 17 after the mutual acceptance. So you need to know if you ever receive an offer, though, as a listing agent, and Form 17 is not in the email or signed, and you don't have a copy of that, you send it immediately to the buyer broker, their firm, your firm, and yourself so you can see who it's all been sent to. And then if you never get a signed copy back, you can prove you gave it to them and they had 3 days for review and they chose to walk through it, and you upload that email into your Form 17 placeholder. Thank you for the question. Here is the preamble. So embracing Form 36 and know how to do it. All terms and conditions of the offer, the real estate purchase sale agreement dated X, concerning the property. by whoever's doing the counteroffer, right? So if the seller, so this would be Mr. and Mrs. Seller as seller, and the undersigned Mr. and Mrs. Buyer as buyer, or however many parties there are accepted, except for the following changes. By them signing the bottom line of this form, all parties, they agree to everything in the purchase and sale agreement. We've referenced it by the property as well as the date it was originally formed. So they accept, whoever signs the very last line accepts everything on this form and everything attached except for the following changes. So adding forms, omitting forms, and so forth. Use for buyer or seller, the undersigned is the counter offering party. All terms of offer are accepted except for the changes made below. But not a good practice, sign only this form. Remember I recommend they sign all of the forms so it is very clear they understand and can see what they signed. So creating that roadmap. Seller is countering a buyer's offer. Form 36 is used to address all items the seller wants to counter. If those same items are not crossed out on the original purchase and sale agreement, and C Form 36 is written beside the crossed out terms, do those places now have to be initialed as well? No, they do not. Okay, this is just what we call a roadmap. Do some people have their clients sign it so they're conscious of the changes? Yes. Is it required to if a Form 36 is in play and signed around? No. What if one party initials and the other does not? Does this mean there's no binding agreement? There is 100% a binding agreement if only one party signs those areas. What if one party signs late or initials late? Does that affect the date of mutual acceptance? It does not. Now, here is a Form 36. You can kind of see the top. The preamble is up here, which you can't see. Here's everything here, and here's where everybody signs at the bottom. This actually happened in one of our offices a few years ago and created a lawsuit. So the seller countered buyer's offer on a 36 and the buyer countered seller on the same form 36. Were all terms agreed upon because of the interlineation and signatures? No. At the bottom, the above counteroffer is accepted. Just because they accepted some interlineations, they never accepted everything else. And this is what got us into a lawsuit. This is not actually our particular case form that the attorney used, but ours was very similar. And it all stemmed from the fact that the seller decided at the end they couldn't afford to sell due to the divorce. And they said, well, we never actually signed the counteroffer all the way. They did the same kind of initials, but they didn't. What else are they initialing to? We have no idea. This is why this form is very specific and you have to have all parties sign, especially at the bottom. Never do this. This is called interlineation. Get a new Form 36 out, write what you still want in play, and write what you don't want in play so that it's very clear. I know that it's probably not very clear on this screen because the type is really small. So, discussions for the prior slide. Forms get messy. I've seen some that I have had to print out, take rulers and highlighters to figure out and decipher what was signed and initialed by which party. Line 27 is a counteroffer expiration date. If you go back to that, that's line here. You'll notice that the line numbers are on the right-hand side. Here's our expiration date. So you put in a physical expiration date. When does counteroffer expire? 2 business days after delivery, in what the party wants during the final negotiations would be that way. But I believe on Form 36, I couldn't read that type really quick. Let me just reference my forms. What it states down here at the bottom. This counteroffer shall expire at 9 p.m. on this date, if not filled in 2 days after it was delivered. So you still get those 2 days if you don't fill it in, just like you do the boilerplate. If the buyer signs before there's agreement to a counteroffer term, what is the meaning of buyer's signature? The above counteroffer is accepted. That's what this says. The above counteroffer is accepted. They haven't accepted this. They didn't sign it. Is it true? No, buyer does not accept seller's counteroffer. Buyer makes new counteroffer, hence why you need a new Form 36. If the 36 is never signed all the way around, it doesn't exist. If you go back to interlineating just the purchase sale agreement, you could get to mutual that way, just so you do know. If the buyer doesn't sign when making an offer, counteroffer, buyer does not accept seller's other counteroffer terms. If the buyer doesn't sign, but the seller initials and accepts, what is the seller accepting? Is the buyer obligated to the other terms of the seller's counteroffer? Do we have a binding agreement? You know, it's very hard to tell. And I think that a judge and jury, which our lawsuit ended up with, is going to have to make the deciding factor. Anytime you talk to an attorney and you ask them a question, you know, I refer you guys to attorneys from time to time because I can't answer those questions because I don't play an attorney except for on TV, but I don't play a legal attorney. That you're going to have your clients talk to an attorney to get to the bottom line. And a lot of them are going to tell you, well, it depends. That's what all attorneys say. So sometimes it has to come down to a judge or jury to figure out what the final outcome is going to be. So interlineating without having it signed all the way around is going to be a problem. We are pushing back hard when we see these. We're pushing back hard when we see closing and or sooner. Talk about that in a little bit. I want to make sure that we have enough time for that to keep us out of some trouble. So use a new Form 36 for each counteroffer. How should the buyer broker have drafted the counteroffer? We're not in a big class, so we're not going to do this part. Use a Form 36, a clean one, and accurately complete the preamble, the top part on who is now making the counteroffer and who's going to accept the counteroffer. Write the buyer's countered purchase price, if that's one of them. Cut and paste acceptable terms from the seller's counteroffer as listing broker drafted them. So when you go back to this part and let's say that buyer accepts the first 4, copy and paste those into the body of the form. Draft new language reflecting buyer's counter-offered terms. Write buyer's counteroffer expiration date and time at the bottom. Get buyer's signature and deliver buyer's counteroffer to the seller's side. Will the buyer broker get paid? And if so, how much? This is the buyer's offer. The red lines were placed on the face of the offer by the listing broker along with C counter. See the next slide. You will notice that there was no offer from the seller, but buyer broker filled in the amount that they were charging their buyer. This is a statewide form, and other parts of Washington State in different MLS systems that are owned by NAR, they're not allowed to publish in the listing how much the seller is actually willing to pay. So the buyer always has to ask for how much the buyer wants the seller to pay their broker. So that's why you'll see some of that with some of these forms. This was the counteroffer. This is seller's counteroffer, but the red line was placed by buyer broker when drafting buyer's counteroffer to the seller. Seller agrees to pay $5,000 towards buyer's closing costs. Seller agrees to pay a buyer broker commission of 2.5% of the sales price. Title and escrow shall be First American Title with Erica M. Is the buyer broker going to get paid 2.5 or 3%? So what this states is buyer is rejecting seller's counteroffer. Dina, do you have an answer?
Yeah, they're getting paid their 3%.
Why is that?
Well, because the sellers in the offer, the seller was, they put in 3% for the buyer broker put in 3%, and the seller's counter offer was crossed out.
Yep. And then this is what the buyer broker wrote. Buyer broker believes that the seller is obligated to pay compensation of 3%. Listing broker believes seller has no obligation. Who's right? Buyer broker is correct, like Dina stated, because what was on 36 was not carried over, and it was finally accepted at the bottom, which you can't see this part because the slide was too big. But the only thing that came over was the purchase price and title and escrow to be First American. So that's what the buyer's agreeing to. Remember, at the top it says the undersigns are accepted. So everything below is accepted except for the following changes. The 3% was never addressed. Oh, hold on just a second. No, I'm sorry. Let me go back to this. So because the seller, I miss Dina, you're not actually correct. I'm going back to, and this is where Annie said that all of the years she taught, she changed how this is actually reading. Because this was a counteroffer, these items are considered accepted because they were already countered, even though it's not reflected in this form. So the buyer broker is only getting paid 2.5% because they did not address all of the seller counter offers through here. Now I'm going to go back to that. Hold on. Pause for a moment because so Annie has taught one way all these years, but because of how this was drafted and not accepted, it became still a counter offer. So that counter offer is still in fact because the 2.5 was not carried over. I mean, it's because the 3% was not carried over, excuse me, because the 3% was not readdressed because it's already been countered at 2.5. So had the buyer broker wanted 3%, they would need to carry it over again to this page,
Okay.
is why. So 36, that's why you want to take everything from this and carry it over. Otherwise it stands. This stands. So again, the buyer broker would need to put on here that they're getting paid 3% because there was already a counter at 2.5. So you're the buyer broker. The seller countered buyer's offer using Form 36. On Form 36, listing broker wrote only buyer to provide proof of adequate funds to close transaction. Now, internalize what you think that means. Buyer and buyer broker talk, and buyer reveals that part of the buyer's down payment is a graduation gift from his parents that have not yet given him most of the down payment funds in the buyer's bank account. Buyer's eager to proceed. Buyer broker knows that buyer must provide a Form 22EF with both contingent funds and non-contingent funds marked. You are the buyer broker. If you draft a document or documents that you will have your buyer sign for delivery. So what forms would you use? What does buyer to provide proof of adequate funds to close the transaction? What does that look like to you?
Are you talking about the evidence of funds form?
Could be. This is on a Form 36. Buyer to provide proof of adequate funds to close the transaction. What does that mean?
I mean, they want them to demonstrate they've got the money, I guess.
Right. And so what does that mean? So does that mean you have to, so as a listing agent, what would you want to see versus just that language? Because if that were to stand, that just has to provide they have adequate funds to close. It doesn't say it has to be in their bank account. It could be in anybody's bank account. Dad's writing a check for half, right? So what would you add as another additional counteroffer to the buyer. You had it right, Samantha or Sumatra.
Oh, the evidence of funds form.
Correct. So you would want to get a new 36 out if that's all that was on there. Or maybe the price, change whatever the price should be.
Mhm.
But I would want you to see that I would want to see a 22 EF attached, right? And on the 36, put on there that Form 22 EF is part of the purchase and sale agreement, adding Form 22 EF to the transaction or to the purchase and sale agreement, and adding a 22 EF and getting that completed, right? Or I would probably, and so would Dina, we would just call a buyer broker saying, we want a 22 EF attached to the purchase sale agreement and resent. Because right here it says buyer broker knows that buyer must provide. There's nowhere in the statement that says buyer has to perform a 22 EF. That's what the buyer broker thinks. And the buyer broker would be what is thinking the correct way that the seller wants the transaction to go. But by simply putting buyer to provide proof of adequate funds to close transaction, and there's no 22 EF as part of the current transaction, the buyer doesn't have to perform a 22 EF. Right?
So if a listing agent just says, hey, can you send a copy of, if it's a cash offer, for example, can you send a copy of client's bank account where they're pulling funds from?
Sure. You want that prior to mutual?
Yes.
Okay, then yeah, you could easily do that. Otherwise, you need an avenue to be able to get that information. If you don't ask for it in the offer, it doesn't have to happen, right?
So all cash offers don't require the proof of funds?
No,
No.
nothing requires proof of funds.
Okay.
So 22 EF is an avenue for protection of the seller. It is a disclosure from buyer to seller. It is not a contingency.
Okay.
It is a form that tells, or hopefully will put the mind at ease of the seller that the buyer has to provide the proof.
Okay.
But if I were to give, back in the old days when we would give cash offers, they just relied on us giving cash offers and hope they had the cash. But now a 22 EF evidence of funds says you have to disclose all of your funds.
Kind of like a promissory note.
Well, not really, because a promissory note has
Oh,
teeth,
yeah.
whereas 22F only has potential teeth to terminate a transaction or show buyer in breach. But
Mhm.
22EF is there to say, okay, seller, I have money coming from this source.
Okay.
And I have X number of days prior to closing to get it, to show you that I have that. So that's why when you're doing an actual offer where you're utilizing 22 EF rather than a 22A financing, because you want a strong offer. I don't want it contingent on financing, but I want to tell you, seller, I'm getting a loan because I have to disclose contingent funds. Those are contingent funds. But you as a buyer broker need to be very careful at the bottom line, because that loan isn't going to come due and in play until the closing date. And I want to say that 22 EF has 10 days prior to closing, you have to prove you have sufficient funds. If you're getting a loan, you don't have sufficient funds yet. So you need to make sure that you have, let me see if I have a copy of it. I want to see the date. That seller has, buyer has 10 days to prove it. You need to take that down to a 0 if you're utilizing 22 EF for evidence of funds versus a 22A. Does that make sense?
So could you use a 22 EF instead of a 22A?
Sure, if you don't want contingency.
Okay.
You have to remember there's no protection for a buyer on a 22 EF.
Okay. And then just really quickly, so if you as a listing agent accept an offer, a cash offer from a buyer, and you did not request a proof of funds and you went mutual, then you can't later go demand a proof of funds.
No, you can't.
Okay.
Yeah,
But you
whether-
can before you go mutual. Okay.
Absolutely. Yeah, I would if you and if I was the buyer broker, I would highly expect a phone call from you. If I give you this loosey-goosey offer, I know that you're going to come back and ask me for X, Y, and Z. You're going to ask me, hey, did your client sign Form 17? Proof of funds. Are you going to send those over now before mutual, or are we going to counter you with evidence of funds? Like all of the things. Remember, if it's not in the offer, it doesn't exist.
Okay.
Okay, time for one more slide. Nope. Can you do a better job than this buyer broker? Buyer listed Form 22R. 22R is the well addendum on Form 21 addenda line. But Form 22R was not attached to the buyer's offer. Seller countered the price. Buyer wants to accept the counter, but only if Form 22R is part of the purchase agreement. Buyer broker had buyer sign seller's counter and return it with buyer's initials on Form 22R. Did buyer broker draft consistently with the buyer's instructions?
No.
No.
Because it wasn't attached to the offer, so it doesn't exist.
Right. So buyer broker should have done a Form 36, address the price, add language adding Form 22R to the purchase and sale agreement. But because the buyer signed the counteroffer 22R, just because it was labeled at the top or in the addenda line, doesn't mean it exists. It has to be attached, and it wasn't attached. They had the buyer sign it, hoping the seller might sign it. And I'm going to tell you right now, there's many listing brokers who put that in front of their seller and sign it, no problem. But wills are a thing that people want to have investigated, just like septic systems or inspections. Many times I have seen offers going back and forth, and something gets omitted or taken out by accident. That's why 36 really keeps things in line, especially if you attach them. And again, once you put language in there saying that 22R is going to be part of the purchase sale agreement, once 36 is signed, even though 22R is not signed by the seller, but it is signed by the buyer, then yes, it is 100% a part of the purchase sale agreement. That's why 36 can help with avenues of omitting or adding contingencies the buyer might want or seller doesn't want. And we are close on time. Let's go for any other questions that might be out there.
Yes, just really quick, because I haven't heard of that. You mentioned something earlier about an extension fee.
Oh, yes. So if a seller, or excuse me, if a buyer wants an extension and seller's like really nervous, maybe they've already been off the market for a month, and maybe it's because the buyer is trying to get something together. Maybe the seller doesn't mind that maybe it's some it's contingent funds the buyer didn't disclose. Let's use just that as an example. And seller might be okay signing an extension.
Mm-hmm.
Then you would do rather than releasing the earnest money, because you still have a contingencies in place because no one's asked them to remove their financing contingency, let's say.
Okay.
Buyer at this point, based on my scenario, is in breach right now anyways, so I may just have the deal tanked, but let's just say they need an extension. Either party needs an extension. Rather than releasing earnest money on the buyer's side, if the buyer wants the extension, do an addendum for an extension fee and pay out an extension fee. I see it all the time in land contracts where buyers like, I want the option to extend it for another 30 days. I will pay a $5,000 extension fee on X date if this option is exercised. So rather than releasing earnest money and you're in a multiple offer situation, I think there needs to be a fee that the buyer pays to leave earnest money intact rather than releasing and making it non-refundable, because there's contingencies in the offer. And that's what that money is there for. That is for when the buyer breaches, the seller also gets this. But if you really want to make your offer more appeasing to a seller, there's many things a buyer can do. Buyer can say, you know what, I will pay for your compensation, buyer broker. Let the seller have that money back. Show that that money is an option I'm giving back, or a fee I'm giving back, so they don't have to pay it, and keep the earnest money intact, or create some sort of a fee for accepting my offer.
Who
That's what I refer to.
determines the amount? The buyer?
Well, both parties. One party can offer, the other party can say, I want more.
Okay.
I mean, that both parties have to agree on whatever it's going to be.
Okay.
Those will be way few and far between right now, at least when it comes to multiple offers, because we're just not having a lot of them. But when earnest money is released as non-refundable and there's still contingencies in play, any judge would tell you, seller, you had no right to it. But here's the thing, if the buyer breaches, then the seller's going to get the money anyway. So it really depends how things are written. Those are just ways that people have practiced what they've learned over the years without really knowing the fundamentals of what it means contractually.
Okay.
So I had an example in one of my other offices where the buyer felt that the home was smaller than it really was. So they told the appraiser, please measure the house. Well, it came out 300 square feet smaller. And when the broker came to me and I said, well, where are you in your 10-day of verification information? Because this buyer wanted $200,000 off the purchase price because they were going based on price per square footage. Well, this house was updated over the years. It had a Fisher Pickle dishwasher. It had upgraded appliances. It had updated bathrooms. And it had all the things, let's say. Price per square footage doesn't come into play when you take two matching houses and one has been updated and the other one has not. Price per square foot is going to be different if they're the exact same house in the exact same neighborhood, but this one's in better condition, better shape, updated, not updated. They're not going to come out apples to apples. They're going to come out apples to oranges or whatever banana, whatever you like better. So I asked, where are you at with your 10-day verification information window? She's like, well, it was waived. I said, okay, was that your choice or your client's choice? Well, I just checked the box. I'm like, again, was it your choice or the buyer's choice? Well, it was my choice. Why would you do that? Why would you take away a contingency from your client? That's the way I've always practiced. And that was the wrong answer. So I need you guys to understand when I tell you it is your client's decision for everything in that contract, it's your job to know every paragraph on every form and tell your clients what all of this means. If they want to make their earnest money non-refundable, that is completely up to them. If they ask you of ways to make their offer more appealing, you can help with that. But if you're going to say, well, a lot of people will make their earnest money non-refundable and release to the seller immediately, buyer needs to understand what that means. Okay? So anytime you're going to give advice to your client that could put your clients, any of it at risk, then you need to follow that up with an email. And when they say, no, I really want to waive my inspection contingency. Well, I'm going to have you sign a waiver of a contingency, but I also want you to understand the risk. You're a buyer beware, buyer due diligence state. By you doing that, you can't have an inspection. So don't think that you're going to waive it now and just ask the seller to have it, or you think I can just let you in the house to have it. I can't. So you need to remind your clients of the risk they're picking as well. And the buyer did realize they did not actually waive their contingency of their 10-day of verification information. Could they have used it? Potentially. We had a verbal on how much smaller the house was versus in writing. And the appraisal did come back low, but only $20,000. But all is well. The transaction is actually terminated and legally based on Form 17. So please, this was a weekend call a few weeks ago. I am happy to take your calls when you get into these little pickles and you've got some pressure on what do you need to do next. So your takeaway here is don't just check a box because that's how you've always practiced. Change your practices or talk to me first. 2, I can sometimes find a way out when there doesn't look to be one. This went on for more than a week of conversations with multiple people to get this finally ironed out and terminated. So it's important for these odd nuances that I've given you today. They're real life situations that have happened to somebody, some firm, somewhere here in Washington State. I see a lot of terrible contract writing that you guys receive from other parties. I am more than happy to walk you through anything, anytime when you get something that you're like, should my client sign it or not? Especially if it's a little odd. When somebody sits there and uses a form 34 to give me bullet points on what's in the offer, that 34 is never going to get signed, number one, and will be removed from the contract. When you send me a 34 that says, there is a discrepancy on an interpretation on what a promissory note is. No, we're not signing anything that sounds weird and funky like that ever. So don't just sign something to get it signed to move forward. I also had to just unravel a situation in one of the offices where the seller signed that the buyer, who did not have an inspection contingency, signed that the buyer can have a walkthrough with the building inspector. I wonder who that person is. I don't know, walkthrough versus inspection. So don't just sign stuff. Don't let them sign stuff. Pass it through me, please. I'm going to let you go unless there's any more questions.
Thank you.
No. Appreciate you, Janine.
Yes, thank
Appreciate
you.
all of you. Have a great afternoon. We'll see you next time.
Okay, thank you.
I want to not be a topic of discussion or a.
You will not. Bye.
Bye.